And the last case I will be discussing today is the City of Holyoke versus Tosado. In January 2020, the City of Holyoke filed an action in court pursuant to General Law 60, Chapter 60, Section 65, to foreclose all rights of redemption on a certain residential parcel. The city recorded an instrument of taking for unpaid taxes incurred during the city's 2015 fiscal year. In accordance with Chapter 60, Section 66, the court ordered an examination of the property's title. That examination revealed that in 2000, the property was conveyed to Gilfredo and Felicita Tosado. The examination further showed that in August 2016, Gilfredo and Felicita Tosado conveyed the property to its current owner of record, Yolanda Tosado. The court's examination identified two possible errors in the notices the city was required to provide to prior owner Gilfredo Tosado in advance of the taking. The city has since demonstrated to the court that one of those errors isn't fatal to the city's foreclosure claims, but the other error is, and hence the court dismissed the action without prejudice. The first, but non-fatal error concerns the city's demand for payment of taxes. Chapter 60, Section 16 requires municipalities to send property owners a demand for payment of unpaid taxes. Section 16 describes what the demand must contain. Section 16 also directs the municipality to serve the demand on the assessed property's owners. The issue here is that the taking states the city sent that demand only to Tosado Luis. No such person ever owned the property. However, the city noted that the demand was sent to Tosado Luis, the fictitious owner, and Tosado Felicita. Felicita Tosado was one of the property owners in 2015 with Gilfredo. While the demand doesn't name Gilfredo, that omission doesn't matter because Section 16 provides that if two or more persons are jointly assessed property taxes, service of the Section 16 demand need be made only upon one of them. So that was the non-fatal error. That takes us to the second fatal error. Chapter 60, Section 53 provides in part, if a tax on land is not paid within 14 days after demand therefore, and remains unpaid at the date of taking, the collector may take such land for the town, first giving 14 days notice of his intention to exercise such power of taking, which notice may be published and shall conform to the requirements of Section 40. What does Section 40 say? Section 40 provides in turn that notices shall contain a substantially accurate description of the several rights, lots, or divisions of the land to be sold, the amount of the tax assessed on each, and the names of all owners known to the collector. The city asserts that it provided a Section 53 notice by publication. However, the published advertisement listed the owners of the property as Tosado Luis, Tosado Felicita, and subsequent owner, Tosado Yolanda. The published notice didn't mention Gilfredo Tosado. The city attributes its omission of Gilfredo's name from the published Section 53 notice to inadvertence and has not offered evidence that Gilfredo Tosado had actual notice of the published advertisement or its contents. The requirements of Chapter 60 are to be construed strictly. Where there is any doubt as to its provisions, they are to be interpreted liberally in favor of a person seeking to recover his or her land. Failing to give either actual or constructive notice to all owners known to the collector, as Section 53 directs, substantially undermines those provisions of Chapter 60 that are made for the protection of the interests of taxpayers, and thereby invalidates a Section 53 notice that doesn't list all such owners. For that reason, the court dismissed the city's foreclosure petition.